Hi, good evening. My name is Hannah May Oporto, and for tonight, I will be discussing to you a landmark case about an agricultural land. The petitioner in this case is the Land Bank of the Philippines, while the public respondent is Honorable Eli G.C. Natividad, the presiding judge of the Regional Trial Court Branch 48 of San Fernando, Pampanga, while the private respondent is Jose R. Caguiat. This is GR number 127198, decided in May 16, 2005 by Supreme Court Justice Tina. So what happened in this case? On May 14, 1993, Mr. Caguiat filed a petition before the Regional Trial Court for the determination of just compensation for their agricultural lands situated in Arayat, Pampanga, since those lands were subject for appropriation. The respondents of such petition, the Department of Agrarian Reform and the Land Bank of the Philippines, were ordered by the court to pay Mr. Caguiat the amount of 30 pesos per square meter as just compensation. Thereafter, motions for reconsiderations have been filed by DAR and LBP but was later on denied by the courts. And so, the LBP appealed before the Supreme Court. According to them, the private respondents should have sought the reconsideration of the DAR's valuation of the subject properties. And so they are claiming that the amount set by the trial court for just compensation should be declared as void. They contend the trial court erred in declaring that Presidential Decree number 27 and Executive Order number 228 are mere guidelines in the determination of just compensation, and in relying on the private respondent's evidence of the valuation of the properties at the time of possession in 1993 and not on Land Bank's evidence of the value thereof at the time of acquisition in 1972. So the issue in this case is whether or not the payment for just compensation should have been based upon the value of the property at the time of its acquisition in 1972 and not at the time of possession in 1993. So what is the decision of the Supreme Court? The decision of the Supreme Court favored the respondents. It was said that the payment of compensation for the property of the private respondent must be based upon the value of the property at the time of the petitioner's possession in 1993 and not at the time of effectivity of Presidential Decree number 27, an agrarian reform, which is how the petitioner acquired the subject property. The Supreme Court mentioned that in one of their past cases, they already held that the seizure of the land holding did not take place on the date of effectivity of PD number 27, but would take effect on the payment of just compensation. In the case at bar, since there was no payment of just compensation in 1972, the price of the property may not be based on that year, but rather in 1993, because it was at the time when the petitioner determined the amount of just compensation. So that would be all for tonight. Thank you very much for listening. Again, this is Hannah May Oporto, a second-year law school student of University of Nueva Cáceres. Ayoko na. That the Z-Shore? At the time when